chance at seeing you.
Welcome to the latest edition of the Cranky Curmudgeon Corner. This evening, we're going to be talking about the Constitution and the courts. With us is Judy Donegan, Samantha Finkenbinder, and Daniel Thomas. Question number one. A couple of shows back, I went off with my disgust of the lack of adherence we as a nation have towards the Constitution. I was particularly referring to the insurrection clause in Section 3 of the 14th Amendment. Thankfully, the all-girl panel was able to calm me down by explaining to my dumbass that the Constitution alone can't be the defining document in determining culpability and involvement in an insurrection. Judy and Sam, I have to thank you two for that. There has to be other statutes on the books that lay out a due process mechanism by which one can be declared ineligible for state or federal office. So, is it always necessary for other laws to be written before the Constitution can be enforced? And what happens when the laws, state or federal, are contrary to the guidelines laid out in the Constitution? It was really clear to me that the insurrectionists should not be allowed to be eligible to run for state or federal office. But there has to be a way to prove that they're insurrectionists. What about other laws? Judy, you're our legal eagle here. So tell us what happens whenever laws are written contrary to the Constitution, and what is the mechanism by which they are brought in compliance with the Constitution?
Well, when laws are contrary to the Constitution, the Supreme Court, of course, has the power to declare them unconstitutional. And I think we'll probably get into that later. But when there is not a statute, the Constitution lays out broad prescriptions about what can be done and what freedoms we have. And generally speaking, Congress will enact a statute to have the mechanism by which those laws or those principles can be enforced. And for instance, Section 1983 actions, which there are endless numbers of them, but that's the mechanism by which people can hold state officials liable for violation of federal constitutional rights. There is no corresponding statute to hold federal officials, like FBI agents and so on, liable for violation of, say, the search and seizure clause. So this is an exception to what I think we told you last time, Paul, in that the Supreme Court allowed an action against federal officials. It's called a Bivens action, after the name of the plaintiff in the case, who sued about an unconstitutional search by federal narcotics agents. So that suit was allowed to go forward in the absence of a statute to support it. And that happened in the 70s. But now
let me interrupt here and ask this question. So was this happened in the criminal? Was this question raised or was it raised civilly?
It was raised civilly. It's a civil case. Now, if it were raised criminally, you would have a defense to a criminal action based on the Constitution. But a civil action for damages because of an illegal search by a federal agent, or in this case, 6 federal agents, was allowed to proceed. Sort of, it's a really weird decision, but this Supreme Court that we have right now and that we've had for a few years is cutting back on that action. So I think that legal theorists are wondering if there will be Bivens actions in the future in the absence of a statute that Congress might enact to allow civil claims for damages against federal agents. So to answer the question of whether there ever can be something based directly on the Constitution, I guess we would have to say yes for that kind of claim, but it's really unusual. And right now it's not favored. But we know just today that citizens in Georgia are suing to have Marjorie Taylor Greene taken off the ballot for her participation, alleged participation in the insurrection. And the judge is allowing that case to go forward. I'm going to be really interested to see, and the judge did acknowledge this was a tricky situation, but I'm going to be interested to see how Greene's participation in the insurrection, to the degree that would eliminate her ability to be on the ballot, how that will be proved, or you know, what are they going to have to show? So
yeah, I saw her come out. I think it was like the 5th or the 4th of January, and walk right up to the cameras and basically said that she came out of a meeting and we were able to, we're going to be able to stop this and keep Trump in office. And she just blatantly came out and said that to the TV cameras that were, so yeah, that will be interesting. Now, based on what they're doing down in Georgia, there was also a suit filed in North Carolina for Madison Cawthorn and a couple people in Pennsylvania. And I think Paul Gosar, his people out in Arizona, are also doing the suit. And what they said in North Carolina with Madison Cawthorn was that because he already has the signatures to get himself on the ballot, we can't stop it from being on the ballot because the ballot's already printed. But whether he's going to be eligible or not, we'll have to have further litigation on that. Okay, Sam, you were also one of the panelists on there that had to give me the chill pill. So tell me what you think about how all of this plays out. Judy gave a very good explanation as to how it works. What's your understanding?
And I'm very grateful for Judy for having pertinent actual legalese advice. But you're talking to a real plebeian here. So, look, as a regular American in society, I think of the Constitution as a set of laws, a set of rules, if you will. And they set the parameter, the Constitution sets our parameters of law in this country. And when laws are written, when people come up with something, take it to the legislature writes the laws, those then need to, either they meet the Constitution's parameters or they don't. If they do indeed pass a smell test, then, they become law, of course. But then you can also get these laws that challenge the Constitution, and you get laws that, while they challenge the Constitution, they also stay within the bounds, the wider bounds of it. So the way you've asked the question is it necessary for laws to be written before the Constitution can be enforced? Yes, of course, because that law challenges the Constitution or affirms the Constitution, maybe a little bit of both. And then, of course, you get laws that, while they affirm the Constitution, they also set precedent for future court cases. I guess that, as far as I'm concerned, the Constitution is there to set guidelines and parameters for laws that are written. And whatever else happens is kind of at the whim of society, culture, and the lawyers at play.
Well, like Judy said, this thing about, I think she said Givens, Judy, that had to be tested in a civil court. So someone had to file a suit to see if that was going to hold true. Dan, do you have any thoughts on this matter, or have we beaten it to death already? Hey, you got to unmute yourself, buddy.
I don't know enough about constitutional law to have a relevant opinion here. I'm a complete layman in this area, so I will defer to the legal expert.
Okay. Thank you, Judy, for helping us out
Thank
with
you,
that. All right.
That's a big
Please.
responsibility. I don't know.
Yeah, I'm going to let you go first on this next question, too. Please assess the effectiveness of the courts in determining whether a state or federal law is contrary to the text of the Constitution, as well as the mechanism used to declare the law unconstitutional and no longer law. Now, we're going to get into that a little bit later, but you already mentioned this Givens thing. How do you think it's working? How well do you think it's working, this mechanism that you described? You get something, you go to civil court, the arguments are made whether it's constitutional or not. Is it working?
I have to just say one thing. It's Bivens with a B.
Oh,
in
sorry.
boy. Yeah,
Bivens.
just so we're not misleading everyone.
Thank you for that.
Yeah, I hated to do it. But, well, how well is it working? I'm not quite sure what we're referring to, but what I like about this question, what I want to talk about, is the mechanism. And I guess it's partly how is it working? What's the mechanism that they use to declare a law unconstitutional, which I think is one of the most ridiculous things that's going on. This whole thing about what is your legal philosophy and how do you interpret statutes and how do you interpret the provisions of the Constitution? You know, are you an originalist? We've all heard that word. And does the Constitution mean to us today what it meant to Thomas Jefferson back then? And I'm always interested in what he thought about the internet. But then the other thing is the other approach. It's sort of inherent in your question when you talk about the text of the Constitution. So there are other people who go at this by what we call textualism, which, you know, just an example to see how these grand terms can be manipulated to mean almost whatever any particular judge wants it to mean. I'm going to talk about a statutory case, not a constitutional case, but a little while ago, Justice Gorsuch wrote a decision in a case involving gender identity in employment. And the issue is, does sex in the statute cover gender identity or not? So using what he thought or said was a textual approach, he decided it did. Remarkably, this shocked everyone in the world, I think, but he just said that sex in that statute did cover gender identity. Well, Justice Alito lost, you know, his hair went on fire, and he accused Gorsuch of, I mean, it's a wonderful quotation. No one should be fooled, he said. The court's opinion is like a pirate ship. It sails under a textualist flag, but actually is something else. In other words, textualists, two of them. And he said, no, of course, sex doesn't cover gender identification. It covers male and female, period. So my feeling is, how effective was all this? I think they profess to be using some grand theory when they're actually getting to a result they want.
So they claim this grand legal philosophy, but the result is what their own biased ideological thinking supports.
That's putting it pretty well.
Okay, all right. Dan?
I don't think that the courts are necessarily ineffective, but I think that they are often bringing their own baggage to the table. And we hear accusations of that on a fairly regular basis against various judges, like not necessarily the Supreme Court, but the lower court. Every time Donald Trump got a decision that was bad for him during his big lie, ridiculous fiasco roadshow. Well, that was a Clinton judge. That was an Obama judge. That was a Carter judge. That wasn't a Bush judge, or that wasn't a Trump judge. Except when the Bush judge and the Trump judge all gave the same reaction, like, this is ridiculous, get out of my courtroom before I have you thrown out or arrested, which was a pretty common reaction from all of those judges.
I think it was 63 out of 64, right?
Yeah.
Adding
He had judges from all over the gamut saying, "Don't insult me with this bullshit." But if that judge had been appointed by a Democratic president, the immediate reaction was, "Oh, well, this person is biased against me." Or if they were if they were a Bush appointee, it was always, the Bushes are upset because of what I did to Jeb. And no, that wasn't the case. Like, these people who were, for the most part, qualified to do their jobs and understood what their jobs were, saw that there was no merit and just got rid of it, because they were not presented with anything within the legal framework that said, yes, you have a right to continue to move forward judicially. So they can and do interpret things according to the letter of the law. The issue, I think, with the fear of judicial activism, which we see on both sides, is, well, the law is shittily written and does bad things. So then the Constitution does not necessarily negate a bad law that does bad things. That's not always spelled out. So sometimes the courts are able to find, yes, this is a violation of a right to privacy, or this is a violation of due process, or this is a violation of your Second Amendment freedoms, or whatever. But other times it's not really black and white, and some things that we think should be illegal are not, and some things that are very legal probably should be illegal, and the court's hands are bound in that way.
Okay, Sam.
I'm taking it as it was written, but I have to comment on something Judy said, because I have to. Thomas Jefferson, I love Thomas Jefferson. I consider him my quote unquote founding father, the one that I always want to quote. And I can't help but think what our current conservative Christians would think of the Jefferson Bible if they got their hands on one and actually reported it. That would be hilarious, where he crossed out all references of Jesus's divinity, you know. But no, as you wrote the question, Paul, and kind of what I came up with, I'm afraid it's not as detailed as Judy's, or certainly not as pointed, but just kind of broadly speaking, the courts, as we think of the courts, they are our final recourse, right, of law. They are where we get the great rules of our society, but they're not infallible. How could they be? We are fallible, humans. The courts are humans. We're all people here. Every inch of it is fallible, from the moment it's written until the moment it's enforced. We accept these things on faith that they're right and moral, and we hope that the greater amount of society agrees that what's been written is moral and right and good, or at least just.
That's more hope than reality, though, right?
Well, yes, but isn't that what the system is? The entire system is a hopeful system. And it's based on integrity. The entirety of our system, especially the judicial branch, is based upon integrity. If the people within the system have no integrity, how can you trust the law? How can you trust the courts? We saw the greatest, and are still seeing it sadly, the greatest fissures in our justice system, our judicial system, with the Trump administration because of the lack of integrity. The lack of integrity amongst that whole administration showed, I think, more than any time in history, in bold-face, black and white lettering, how easy it is to circumvent the system, how easy it is to undermine it. And I just come back to, and I think I said this the last show I was on, it takes people with integrity. People who say, no, I'm sorry, this is a lie. No, I'm sorry, I'm wrong, or I don't know. To admit their wrongs, to admit, or to say, that guy is wrong. This guy is wrong. What kind of judicial system do you have when people claim that falsities are facts? What kind of constitution do you have when people claim falsities are facts? How do you apply a constitution to a society that wants to claim that alternative facts are real life?
I don't know.
Yeah.
I think it's hard, and I believe that we're all coming to that conclusion here. All right, there are a lot of good amendments that have the intention of advancing society. The 19th, giving women the right to vote, is one particularly good example, but my favorite is the 14th, which essentially states that everybody should be treated the same under the law. Do you believe that the 14th Amendment has been effectively applied or basically ignored by court rulings since its ratification in 1868? We had an election in 1876 where Rutherford B. Hayes, who didn't get the most votes, became president. He immediately pulled the federal troops out of the South, ending Reconstruction, and Jim Crow started up, and the people of the South basically decided that they were going to ignore what the 14th Amendment said, which was everybody has equal protection under the law and everybody has the same rights under the law. So that's my example of where the 14th Amendment was ignored. Sam, do you have any other examples, or do you think it's been effectively applied over time?
Well, keeping with your example, I think my whole family is from Alabama, and I think in that case, they never saw any of those union laws as applying to them to begin with. You know, my mother can reference, my mother is 76 years old, and she can reference people in her family that would still say, the ones who are still living, quote unquote, the South will rise again. It's this idea that they can do better than the unionized laws, the Union Constitution. Speaking separately from that, I think that the 14th Amendment, it's wonderful. It's all well and good. It's a great idealism. It's a wonderful ideologue, and we should all prescribe to it, of course. But when you apply it, it's not always going to apply well, is it? Because everybody isn't equal down to, under the law, they should be. But when you try to apply it in courts, it doesn't always work. I think it comes down to what your rights are versus what my rights are, or somebody else's rights versus this other person's rights, or this group's rights versus that group's rights. Because equality and rights more or less mean the same thing. If free speech is a right, and it is. Is it okay to go into the streets and shout white supremacy? Yes, absolutely it is. Are the consequences of you going into the streets and shouting white supremacy? The consequences of that could be somebody, I don't care their race, coming up and punching you in the face. Does that person have the right to do that? Under the 14th Amendment, they kind of do.
Well, I think it was Thaddeus who said that, my right to do what I want, as opposed to your right to do what you want, ends where my nose begins. So if you invaded my personal space and punched me in the face, then what you're doing is you're invading my rights. But me saying it doesn't really punch you in the face.
But if you say it enough and your saying it becomes law, which is actually happening in the case of Roe v. Wade, something is being said enough and pushed enough and pushed enough that it is going to upend a law, aren't you then infringing upon my rights with words?
If it becomes the law, yeah.
Yeah, if it upends a settled law. I guess I see this as the 14th Amendment is a wonderful ideology, and I wish that people in general and courts certainly would adhere to it better. But it comes down to, where do my rights infringe upon your rights and your rights infringe upon mine?
Okay, Dan, Sam brought out a good point. My rights infringing on your rights. How do you see your rights being protected and other rights being infringed upon? Or do you see it that way at all?
Well, I'm a big proponent of the idea that you're free to do whatever you want until it threatens somebody else. So as long as you're willing to face the consequences for your actions, cool, go do what you got to do. I do think that everything in the Constitution has to be challenged. And we have a lot of historic examples of situations being challenged in court that are resolved the right way under the 14th Amendment. Roe versus Wade and Planned Parenthood versus Casey they're not statutory law. They don't have a statute written about them that guarantees the right to an abortion, but under the 14th Amendment, the Supreme Court in 1973 and 1992 ruled that a woman's right to privacy is protected under the 14th Amendment, and that's what we get. Now, whether Serena Joy Barrett is going to agree with that is probably unlikely, but we'll see in about 3 months. It was nice being equals with you ladies. I'm sorry that you're going to not be anymore. But Brown versus the Board of Education was also decided under the 14th Amendment, that separate and equal is not equal. Obergefell versus, I should know this one. I had it. The Hodges. Obergefell versus Hodges also decided under the 14th Amendment, because same-sex marriage does not actually hurt anyone, and the inability of a same-sex couple to marry limits their rights in a way that is not fair to them. So yeah, I think it happens, but it only happens when there is actual judicial challenge to it. And even then, it won't always happen the right way. It's been a long time since civil rights history in high school for me, but I'm pretty sure that Brown versus the Board of Education fell in front of the Supreme Court, or had a predecessor in the Supreme Court where they decided the wrong way.
Plessy versus Ferguson, I think, was the one.
Yeah, that sounds familiar to me. So they tried it, and in the highly racist past, if separate but equal had been equal, then we would be an even more segregated and polarized country. But it wasn't equal, and it could not be argued to be equal in the eyes of the law. So I do think that the only way that we can make a determination as to whether or not we're following the rules are whether or not we bring challenges to them to make that determination. And if we are determined wrong, we keep on bringing the challenges back.
Okay, Judy, the 14th Amendment applied effectively or basically ignored?
Well, I think since, say, 1965 and the Civil Rights Act, we have had a series of beneficial applications of the 14th Amendment, which Dan just went through some of them. There are many more. Interracial marriage, for instance, a lot of prison reform. So I think it is used successfully a lot of times to improve the society. I want to go back, though, to what Samantha said a little while ago. I totally agree with her assessment that we need integrity and good faith in order for this government, courts, I would say not just the courts, but the Congress, the legislative branch, and the executive branch to function. And what happened under Trump, in my view, is that when you have somebody who doesn't seem to get that we need those norms, then, as she said, it's easy to see things upended. It's a little off the subject here, but I think that the nature of the Supreme Court and the makeup of the Supreme Court affects, of course, how well the 14th Amendment will be implemented. Are they going to overrule Roe v. Wade? Are some of those principles that we apparently all think are really good things? And of course, there's a vast number of people in this society who do not think that was a good thing. So the nature of the court depends on how those rights are going to be balanced, I think. I don't make any predictions here.
Okay. There have been a number of mistakes in the original articles of the Constitution. One particularly horrendous example was the 3/5 clause, which essentially codified slavery. It took a 4-year war and 750,000 dead soldiers to address that atrocious error. But there is another profound mistake that still hasn't been fixed. Article 2, Section 2 gives state legislatures the power to appoint electors who determine which presidential candidate gets the electoral vote that is counted by a joint session of Congress. Traditionally, a ceremonial process. The events preceding and subsequent to January 6th should have proven that this system is no longer workable. Is it not finally time to discard the Electoral College and constitutionally mandate that the person who gets the most votes is the one who wins the election? Sam, we are in deep doo-doo here because of this mistake that the founding fathers made about the state legislatures, because they're all working full time now to try to make what didn't happen on January 6th happen the next election.
Well, I think when it was made, it wasn't a mistake, but it has become one. And the Constitution should be a living document. It is supposed to be a living document. That means change. Life means change. And, I don't have any grand fix. Like I said, I'm just a plebeian American, just another person in society. But I do wonder what would happen if, instead of an electoral college, we had nationwide ranked choice voting. What would that do? Would that be a working or a workable fix to the problem with the Electoral College. I think now, I'm not trying to label myself here, and I hate labels, by the way, but Republicans abhor the idea of deleting the Electoral College. Uh, Progressives love the idea of deleting it. But
For strictly power reasons.
sure, exactly. But what would happen with ranked choice voting? I'm not the sharpest knife in the drawer, but I would think that with getting rid of the electoral college and replacing it with ranked choice voting, I would think it would allow for greater input from parties that are often ignored. And one of the greatest issues we have right now is this two-party system, which our country was never supposed to be a two-party system. So perhaps if we brought in ranked choice voting instead of the electoral system, maybe that would be a fix. Of course, it would upset all of rural America to get rid of electoral college. They would immediately think they wouldn't be heard. I think there needs to be greater education concerning ranked choice voting.
Well, I mean, what basically they're saying, the rural people that would be upset was that we want to have minority rule. We want rural America to have more sway than urban America, when urban America has a whole lot more people than rural America.
Sure, and that's a population game, but ranked choice voting kind of corrects for that because of how many representatives you have, how many senators you have. If we keep those numbers, even if we keep them static, ranked choice voting still allows for greater majority vote, if you will, than electoral college.
Okay, ranked choice voting, Dan, over maybe popular selection, the person that gets the most votes. Before we go, let Dan answer that. Sam, give us a broad definition of what you understand ranked choice voting to be.
Well, broadly, I hope I'm not wrong in front of Judy here. Ranked choice voting, you're given four candidates and you number them 1 through 4. 1 being your choice vote, 2 being your second best, if you will, 3rd being your 3rd choice, and 4th being your 4th choice. Now, as it goes down the line, it becomes, a battle between kind of 1 and 2 and 3, and then so on and so forth, and whoever gets the most votes wins.
All right, Dan, ranked choice, popular voting. What do you think we need to do about these presidential elections? Certainly, you're not in favor of electoral college. I would hope not.
No, I don't like the Electoral College. In 2 of the presidential elections that I've voted in, the person who won the popular vote, the people's presidents, Al Gore and Hillary Clinton, were denied the opportunity to serve based on a minority of voters. So yeah, that system is obviously flawed and broken. You brought up a failure of the Constitution as the 3/5 clause, and the Electoral College and the 3/5 clause have the same origin story. They were created so states that did not have huge voting populations compared to other states could still have a louder voice than they would be entitled to. And it's a horrible injustice that the population of Wyoming has a louder voice in the governance of the country than the population of Washington, D.C. Because that city is more than twice the size. So there's absolutely no reason why those people should not be heard. So no, I'm in favor of any kind of reform. I already know the arguments. There's going to be federal overreach. New York and California are going to control the election. States have the rights because states only have rights when states are doing something awful. Then it's a states' rights issue. But as soon as you make these arguments for ranked choice voting, that will be the immediate response. And the logic behind the Electoral College really hasn't changed. The minority population wants to have an outsized influence. So it's a little more subtle than apartheid in South Africa, but not by much. But yeah, it's definitely got to go. The origins are based in racism. The results are based in racism. It dilutes minority votes because minorities tend to live in the ethnic minorities, I should say, tend to live in the cities where where most of the people do. The rural population has a voice. Convince the people in the cities that your needs are our needs and our needs are your needs, and we will vote together. But if the needs are basically separate, then the people in the cities are going to vote one way and the rural people are going to vote another way, and it's not, the cities are going to win. So our needs are really not all that separate. The people in the cities need the food that the people in the country are growing. We all have that same basic biological need. People in the cities need more services from their government because they cannot be as self-sufficient because we can't grow in large tracts of land. We require things like trash removal because we can't burn locally. So we have some different priorities, but in general, I think we need food, we need healthcare, we need access to water, we need broadband internet now. We can make all of these things happen, but we have to convince each other of what's important. And we have to stop trying to convince each other that one person's presidential candidate rapes children in her evil sex trafficking ring in the basement that doesn't exist. We got to stop that part, and then we can start on real reform.
In the pizza shop.
Yes, where there's no basement.
Okay, Judy, the Electoral College basically is the question here. What's your take on that?
Well, I'm pretty naive or uninformed on this issue, I think. In the state where I live, we will have our first ranked choice voting in the coming election, and I'm eager to see how it will work. There was a referendum which instituted ranked choice voting here. Samantha, correct me when I get this wrong. And I recall talking with a pretty savvy political figure before that election, before the election where the ranked choice voting was on the ballot. And I said, well, how do we feel about this? Is this a good thing or not? And what I was told is, well, I thought you knew more than that. So I really see the problems with the Electoral College, and certainly with the statute as it's written and as it was allowed to be manipulated this time.
Yeah, and if they can go ahead and convince alternate slates of electors like they tried to do this time, you have a real problem.